Most people, when they walk into a courtroom, understand instinctively that the rules have changed. It doesn't matter who you are outside those doors. It doesn't matter how much money you have, how many properties you own, how many people answer to you on a regular basis. The moment you step into that room, there is one person in charge, one voice that carries final authority, and everyone else, regardless of status, regardless of net worth, regardless of how untouchable they have felt for most of their adult lives, is subject to it. Most people understand this. Raymond Hollis did not. Or perhaps more accurately, he understood it and decided it didn't apply to him, which, as it turned out, was the most expensive decision he would ever make. Not just financially, though the financial cost was significant, but in every other sense, his reputation, his business, his standing in the community he had spent decades cultivating. The damage was total, and it was entirely self-inflicted. This is the story of how a man who owned 47 rental properties walked into a courtroom expecting to win and left with nothing but a public record of exactly who he was. Raymond Hollis had been a landlord for 23 years. He had started with one property, a duplex he had inherited from his uncle at the age of 34, and had expanded from there with the kind of patience and aggression that characterizes people who are genuinely good at accumulating things. He reinvested rental income. He leveraged equity. He bought distressed properties in transitional neighborhoods, made minimal improvements, and rented them at maximum market rate. By the time he was in his mid-50s, he controlled 47 units across 11 buildings in 4 different zip codes. On paper, he was a success story. In practice, he was something else. The tenants who had rented from him over the years described a consistent experience. Initial impressions were manageable. The properties were functional if not well maintained. The lease agreements were standard. The early interactions were businesslike. But the moment a tenant raised a maintenance concern, or requested a repair that cost money, or questioned a fee on their statement, something shifted. Raymond became difficult, slow to respond, dismissive. If the request was repeated, he became hostile. And if a tenant persisted, if they documented their concerns, if they contacted a housing authority, if they cited their legal rights as renters, Raymond became something that several of his former tenants described in nearly identical terms. He became the kind of landlord who made you feel like living in his property was a privilege he could revoke at any moment. That feeling was not accidental. It was a management strategy. The case that finally brought Raymond Hollis before a judge was filed by a woman named Cecelia Varga. Cecelia was 44 years old, a medical billing specialist who worked from home and had been a tenant in one of Raymond's buildings for 6 years. She was a model tenant by any reasonable standard. Her rent was never late. She had never received a noise complaint. She had, over 6 years, submitted exactly 4 maintenance requests: a broken heater, a leak under the kitchen sink, a faulty electrical outlet, and a persistent mold issue in the bathroom. The heater had been repaired after 3 weeks and 2 follow-up calls. The sink leak had been repaired after 5 weeks and a written notice citing health and safety provisions. The electrical outlet had never been repaired. The mold had never been addressed. In the 5th year of her tenancy, Cecelia had begun photographing the mold. She had documented its growth across several months. She had submitted formal written requests via certified mail, referencing the specific habitability standards in her lease and in the state's landlord-tenant statute. She had received 2 responses, both vague, both promising that someone would be in touch to assess the situation. No one came. In the 6th year, her doctor told her that the respiratory symptoms she had been experiencing for several months were consistent with prolonged mold exposure. She had an inhaler prescription now. She had missed 4 days of work. She had medical bills. She contacted a tenant rights attorney. The attorney's first letter to Raymond Hollis was professional and direct. It cited the specific violations, the documentation Cecelia had compiled, the medical evidence, and outlined the remedies being requested: full mold remediation, reimbursement for medical costs, and a rent reduction for the period during which the unit had not met habitability standards. Raymond's response came 12 days later. It was a notice to vacate. This is the point in the story where some tenants give up. The notice to vacate, even when it is retaliatory, even when it is legally invalid, even when it violates explicit statutory protections against exactly this kind of response, creates a pressure that is very difficult to absorb when you are also managing health problems and work and the ordinary demands of keeping your life running. The threat of displacement is not abstract. It is immediate and physical and deeply frightening, and landlords who use it as a weapon understand exactly what they are doing. Cecelia Varga did not give up. She told her attorney to file. The case was assigned to Judge Margaret Sorrell, a family and civil court judge with 22 years on the bench who had, in the course of her career, overseen a substantial number of landlord-tenant disputes. She had seen the full range: legitimate disagreements, genuine misunderstandings, good faith failures on both sides. She had also seen deliberate exploitation, targeted retaliation, and the specific kind of arrogance that comes from spending years in a position of power over people who feel they have no recourse. She was not easy to impress. She was not easy to intimidate, and she had a particular and well-documented intolerance for people who wasted her time. Raymond Hollis was about to waste her time in a way that she would not forget. Raymond arrived at court with his own attorney, a man named Frank DeLuca, who had represented him in 3 previous tenant disputes, and who had, each time, managed to negotiate settlements that were favorable to Raymond without the matters going to full hearing. He had advised Raymond, before this hearing, to be measured, to let him handle the arguments, to avoid direct confrontation, and to present as a reasonable property owner who had experienced a communication breakdown with a long-term tenant. Raymond had agreed to this strategy in the meeting where it was discussed. He abandoned it approximately 11 minutes into the hearing. The early portion of the proceeding was procedural. Judge Sorrell reviewed the filings, confirmed the timeline of the tenancy, established the documented maintenance requests and their response history. She was methodical and brisk, and she directed questions at both attorneys in a way that was efficient and unambiguous. Raymond sat at the defendant's table in a dark blazer and watched the proceedings with the particular expression of a man who believed he was in the wrong room. Not nervous, not humble, impatient. Like someone who has arrived at an appointment that should have been handled by an assistant. When Cecilia's attorney began presenting the mold documentation, the photographs, the dates, the certified mail records, the medical reports, Raymond leaned over to DeLuca and said something that several people in the room, including the court reporter, could hear. "This is a complete waste of a Tuesday." Judge Sorrell looked up. "Mr. Hollis," she said, "if you have something to contribute, you'll have the opportunity to do so at the appropriate time. Until then, I'd appreciate your silence." Raymond looked at her, not with contrition, with the brief, flat assessment of someone recalibrating how seriously to take an obstacle. He was quiet for another 6 minutes. The documentation Cecelia had compiled was, by any measure, thorough. Her attorney walked through it systematically. 41 photographs taken over 18 months, each time stamped, showing the progression of mold growth across the bathroom wall and into the grout around the shower unit. 7 pieces of certified correspondence requesting remediation, with delivery confirmations. 2 responses from the property management company acting on Raymond's behalf, both non-committal. A letter from her physician connecting her respiratory symptoms to chronic mold exposure. 4 medical invoices totaling just over $3,000. And then the notice to vacate, dated 11 days after the attorney's letter demanding remediation. A document that, under the state's landlord-tenant retaliation statute, was not just improper, but explicitly prohibited. Judge Sorrell reviewed the timeline herself, comparing dates. She asked Cecilia's attorney to confirm when the attorney's demand letter had been received by the property management company. The date was confirmed. She asked when the notice to vacate had been generated. The date was confirmed. She looked at DeLuca. 11 days, she said. Would your client like to offer an explanation for that timeline? DeLuca began a prepared answer about standard lease review cycles and the coincidental timing of a broader portfolio assessment. And Raymond interrupted him. It wasn't coincidental, he said. She was causing problems. The room went very still. DeLuca turned to his client. Judge Sorrell set down her pen. Mr. Hollis, she said carefully, do you understand that you just described the notice to vacate as a direct response to your tenant's legal complaint? Raymond heard what she was saying. He processed it. And then he did something that no one in that room, not his attorney, not the court staff, not Cecelia herself, had quite anticipated. He leaned forward and pointed his finger at the bench. Let me be very clear about something, he said. I have been a property owner in this city for 23 years. I have paid taxes, I have provided housing, and I am not going to sit here and be lectured about my responsibilities by someone who has never— Mr. Hollis, Judge Sorrell's voice had not risen. If anything, it had dropped. Remove your finger from that position. Raymond did not remove it immediately. That was the moment. Not the one that followed, though what followed was significant. That moment, the pointed finger, the half-second of refusal, was where everything that happened next was decided. DeLuca physically touched his client's arm. Raymond lowered his hand. Judge Sorrell looked at him for a long moment, with the expression of someone who has just confirmed something they suspected. You will not speak again in this courtroom unless I address you directly, she said. You will not interrupt your attorney. You will not gesture at this bench. And if you are unable to observe those 3 conditions, I will hold you in contempt, and we will continue this hearing without your presence. Do you understand? Raymond said that he understood. He did not look like a man who understood. He looked like a man performing understanding while calculating his next move. Judge Sorrell returned to the file. What followed over the next 40 minutes was a dismantling that was all the more effective for being entirely procedural. Judge Sorrell worked through the evidence with the focused attention of someone who had already formed a clear picture and was now confirming its dimensions. She reviewed the habitability standards required under the state code. She reviewed the lease provisions relating to maintenance obligations. She reviewed the correspondence timeline in detail. She noted that the electrical outlet Cecelia had reported in year 3 of her tenancy had never been repaired, a fact that DeLuca attempted to characterize as an oversight, and that Judge Sorrell characterized as a 3-year ongoing violation of the lease's warranty of habitability. She noted that the mold issue had been acknowledged, twice in writing, by the property management company, which meant Raymond could not claim ignorance of the condition. She noted that Cecilia's medical documentation had been prepared by a licensed physician and had not been disputed by any counter-documentation from the defense. And she noted, carefully for the record, that the notice to vacate had been issued within 11 days of a formal legal demand for remediation, following 6 years of uninterrupted tenancy and no prior lease violations. Under the statute, she said to DeLuca, a notice to vacate issued in response to a tenant's exercise of their legal rights is presumed retaliatory. The burden shifts to your client to demonstrate a legitimate, independent basis for the notice. Can you provide that basis? DeLuca spoke for 3 minutes. He referenced lease language about property owner discretion. He referenced a clause about tenancy renewal terms. He was doing his job, which was to construct the most defensible possible version of an indefensible position. Judge Sorrell let him finish. The lease renewal clause you've referenced requires 60 days' notice prior to the end of the lease term, she said. Ms. Varga's lease term does not end for another 4 months. The notice to vacate does not meet that threshold. Is there another basis? There was not. Raymond shifted in his chair. He was not a man accustomed to watching someone systematically disassemble his position. His jaw was tight. His hands were flat on the table in front of him, in the way of someone actively choosing not to move them. Judge Sorrell called a brief recess. In the hallway, DeLuca had a conversation with Raymond that those nearby described as urgent. DeLuca was clearly recommending something, a settlement offer, a concession, some form of retreat before the ruling was formalized. Raymond was shaking his head. When they returned, DeLuca requested permission to approach and indicated that his client wished to make a statement for the record. Judge Sorrell permitted it. Raymond stood. What he said was, structurally, an attempt at a defense, but it contained within it several things that no experienced attorney would have allowed a client to say in a courtroom, and which Raymond said because his attorney had not been fast enough to stop him, or because some part of Raymond had decided that the truth, as he experienced it, was more important than the strategy. He said that he had dozens of tenants who never complained and whose units he maintained without issue. He said that certain tenants created problems by having unrealistic expectations. He said that he had not survived 2 decades in the rental business by being walked over by people looking for a payday. He said that Cecelia Varga had been, from his perspective, exactly that kind of tenant. In the courtroom, the phrase landed with the weight of something irrevocable. Cecelia Varga, sitting at the plaintiff's table, did not react visibly. Her attorney made a note. Judge Sorrell looked at Raymond Hollis with an expression that was not anger. Anger would have been easier to dismiss, but the particular stillness of someone who has just been given exactly what they needed. "Mr. Hollis," she said, "sit down." The ruling came the same day. Judge Sorrell did not take extended time with it. The facts were not disputed in any meaningful sense. The law was clear. What remained was the question of remedy, and she addressed it with the same precision she had brought to everything else. The notice to vacate was voided. Cecelia Varga's tenancy was protected under the state's anti-retaliation statute, and any subsequent attempt to remove her on the same basis would constitute contempt of court. Full remediation of the mold condition was ordered, to be completed within 30 days by a licensed remediation contractor at the landlord's expense, with completion subject to court-appointed inspection. Repair of the electrical outlet was ordered within 14 days. Medical expense reimbursement was awarded in full, $3,040. Rent abatement for the 22 months during which the unit had failed to meet habitability standards was calculated and awarded. The retaliatory eviction attempt, Raymond's own words, having removed any ambiguity about its nature, resulted in additional statutory damages under the anti-retaliation provision. The total judgment against Raymond Hollis came to just under $41,000. And then Judge Sorrell did something further, which she was not required to do, but which she clearly considered necessary. She referred the case to the city's Housing Compliance Office, noting that a landlord controlling 47 units who had demonstrated both a pattern of habitability failures and a willingness to retaliate against tenants exercising their legal rights warranted inspection of his broader portfolio. She also referred Raymond's conduct during the proceeding, specifically the gesture toward the bench and the statements made without counsel's guidance, to the record, noting that while she was not issuing a formal contempt citation, the behavior had been observed and documented. "You came into this courtroom," she said, addressing him directly for the last time, "as though your years in business were a credential that superseded this process. They are not. You have rights as a property owner, and they are meaningful, but they do not include the right to retaliate against a tenant for seeking medical help, or to point your finger at this bench when you don't like what you're hearing. I hope the next 23 years of your career reflect some understanding of that." She closed the file. The housing compliance inspection of Raymond Hollis's portfolio began 5 weeks later. What inspectors found, working through the 11 buildings over several months, was not surprising to anyone who had rented from him. But documented, systematically and officially, it was significant. 16 units with outstanding maintenance violations, ranging from minor code issues to 3 cases of mold or water damage comparable to what Cecelia had experienced. 2 buildings with electrical systems that had not been brought up to current code following a requirement that had been in effect for 4 years. 14 of his current tenants were identified as having active maintenance complaints on file with the City Housing Authority that had never been resolved. 6 of those complaints were more than 18 months old. The compliance process was slow. It involved notices, response periods, re-inspections, and the layered bureaucracy that makes housing enforcement frustrating to watch from the outside. But it moved. And it moved specifically because a judge had flagged it, which meant it carried a weight it might not otherwise have carried. By the end of the compliance process, Raymond had been assessed significant remediation costs across his portfolio. Several of the buildings required work that was expensive enough that he chose to sell them rather than bring them into compliance. The forced sales, in the compressed timeline his financial situation created, were not profitable. 3 properties went at below market value. His portfolio, which had been 47 units, was reduced to 22. His property management company lost 2 of its contracted buildings over the same period, when building owners terminated the relationship following the compliance investigation's public record. Raymond Hollis did not go to prison. He was not ruined in any absolute sense. He still owned 22 rental units. He still had income. But the version of himself that had walked into that courtroom, the untouchable landlord, the man who pointed at judges, the man for whom tenants were a nuisance to be managed rather than people to be housed, that version did not survive the year. Cecelia Varga stayed in her apartment. The mold was remediated properly. She watched the licensed contractor work and photographed the completed job for her records, because she was that kind of person now. The electrical outlet was repaired. Her respiratory symptoms improved over the following months as the air quality in the unit improved. She did not celebrate publicly. She updated her attorney, paid her outstanding legal fees from the awarded reimbursement, and returned to her regular life. Medical billing, working from home, the ordinary texture of a person's days when they are not consumed by a legal fight they should never have had to pursue. When asked later by a neighbor who had heard about the case whether she was glad she had fought it, she said something simple and precise. "I was right," she said, "and I had the papers to prove it. It would have been wrong to let that go." Raymond Hollis had built his entire understanding of his business on a particular assumption, that the people renting from him were, by definition, in a weaker position than he was, that this weakness was structural, permanent, and sufficient to protect him from meaningful accountability. For 23 years, that assumption had largely held. Cecelia Varga was not weaker than he had assumed. She was documented, persistent, and unwilling to absorb an injustice simply because absorbing it was easier than fighting it. Judge Margaret Sorrell was not the kind of authority that adjusts to the room. She was the kind that expects the room to adjust to her, not out of ego, but because she understands that a courtroom without that expectation is not a courtroom at all. When those 2 women occupied the same room as Raymond Hollis, the gap between who he believed he was and who he actually was became impossible to sustain. The most dangerous thing about a person like Raymond Hollis is not the cruelty, when it is present. It is the indifference. He did not lie awake at night thinking about Cecelia Varga's cough. He did not wonder about the other tenants whose maintenance requests sat unanswered. He had removed them, psychologically, from the category of people whose experience he was responsible for. They were line items, occupancy rates, revenue streams. That kind of indifference is not dramatic. It is quiet and consistent, and it causes harm in exactly the way that quiet, consistent things do, gradually, invisibly, until it becomes impossible to ignore. What the courtroom did was make it impossible to ignore, and what the consequences did was make it costly. That combination visibility plus cost, is the only thing that reliably interrupts that kind of indifference. It should not require a woman to develop respiratory problems and spend 2 years fighting a legal battle for the interruption to happen. But it did. And when it did, the interruption was complete. Raymond Hollis still owns 22 units. Whether the person managing them today is meaningfully different from the person who pointed his finger at a judge in a civil courtroom is not something anyone outside his buildings can know with certainty. But 14 people who might otherwise have spent years in deteriorating apartments because they felt they had no recourse now have a public record showing that they do. That record exists because one woman documented a bathroom wall for 18 months. Because one attorney filed a case instead of a settlement offer. Because one judge asked the right questions, listened to the answers, and then said clearly and for the record exactly what she had seen. The courtroom is not perfect. It is slow and expensive and inaccessible in ways that matter and that should be addressed. But when it works, when the documents are in order, and the authority in the room refuses to be impressed by the wrong things, it can close a gap that nothing else can close. Raymond Hollis walked in expecting the room to defer to him. The room did not defer, and everything that followed was simply the consequence of that single, uncomplicated fact.